Hello and welcome to No Confidence. I'm your host, David Myrland. Nothing you'll hear me say is intended as legal advice. Anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis. Believe it. It's June 3rd, 2023. And I've sold a few flash drives. For anybody that doesn't have theirs yet, go to my YouTube channel, Take from Caesar. And one of my most recently uploaded videos is about the flash drive. So read the text below the flash drive, watch the 1-hour video where on screen I navigate the contents of the flash drive to show you what's in it. And there are a few comments about what's in it in the text below the video, so I urge you all to visit that video on Take from Caesar, my YouTube channel. Today's topic, malicious prosecution and understanding it. It's vitally important. It made me stop and reflect on my 30 or 33 years of legal advocacy, helping others. And all this time, all these instances where the IRS screwed somebody over, or a county sheriff or a city cop somewhere in some state, and you hear what happened to the victim over the phone, as I did. I've taken hundreds and hundreds of impromptu calls with victims of abuse. And thinking back on all of that, there are instances that are so obviously major federal felonies. It's hard to win an argument, it appears, sometimes, that the Fed has no police power within a state. And so you have cases like U.S. versus Lopez, 1995, Supreme Court. The U.S. was forced to appeal all the way to the Supreme Court, and the U.S. lost. Lopez was a San Antonio, Texas youth that took a gun to school, and they charged him federally under the Safe School Zone Act or something like that. And the ruling was that the federal police power only applied where there was a substantial effect on interstate commerce. And they ruled that this kids taking a gun to school did not substantially affect interstate commerce. And so Congress had no police power. In U.S. versus DeWitt, 1870, Supreme Court said that the federal government here is exercising police power inside of a state, and it can't do that. U.S. versus DeWitt was a case where Congress made a law prohibiting the sale of naphtha oil within the state where it was legal to purchase and use that oil to power lanterns for light. And they found that that oil was very volatile, very flammable, and that it caused a lot of fires when lanterns were upset or broken. So Congress set about prohibiting its sale within a state, and the Supreme Court says Congress isn't exercising taxation authority here. This is pure police power, and it's within a state, and so it doesn't stand. And yet, you have something I haven't researched yet. There came a juncture where you couldn't rely on cases like that, and they called it the dual sovereign doctrine. So you'll see the Fed pick up a methamphetamine case where the methamphetamine was made within a particular state, sold within that state, and consumed within that state. And they'll still pick up a drug case. They did it with marijuana a whole bunch. So you have a bunch of obviously intra, meaning interior, intrastate conduct and commerce, illegal or otherwise, that the Fed simply says it has authority over, when case law says otherwise. But then you run into this dual sovereign doctrine. Until that doctrine came along, it was the opposite. 1870, U.S. versus DeWitt. This is police power. Congress doesn't have authority within a state. So somewhere that wrench got thrown in the gears. However, where I'm going with this is the time at which you may be told these federal statutes don't apply inside of a state. The federal kidnapping statute, conspiracy against rights statute. Now we're progressing toward malicious prosecution. You're going to have state analogs, statutes that are very similar to these two federal statutes. So a lack of federal authority is a slight deterrent. But I would guess that your state's combination of statutes come at least close to constituting a capital offense, unless your state doesn't have the death penalty, right? So I want to ring the death penalty bell. I've already been over and over for years the way to ring the felony bell. I want to ring the felony bell. I want to detect when a public servant has committed a felony. Why? Because reasonable suspicion of felony has been committed confers the right upon every American to make a citizen's arrest upon that person, coast to coast. Except in California, they've really messed that up. So, the federal statutes, they're in the chat, top of the chat. The Title 18 crimes, Title 18 Section 241, conspiracy against rights, and 18 U.S.C. 1201, kidnapping. The third clause of 241, you see it says that if the conspiracy against rights, what rights? And you read up above it, if someone conspires against my rights that I have under a particular statute, like the Freedom of Information Act, or the Administrative Procedures Act, 5 U.S.C. 706, that requires the court to do all these things when presented with an issue at law, we know they won't interpret tax law. And if it's in a criminal case, they're trying to kidnap somebody. So we go to 1201, definition of kidnapping. If any person, that means it can be one person, if any person grabs somebody else, confines them, inveigles them, carts them away and holds them for ransom or otherwise, that's a kidnapping. If someone unlawfully does that. And then you go back to 241, did two or more people try to kidnap a person? That's a conspiracy to kidnap. A conspiracy to deprive somebody of liberty. So you go to 241, the third paragraph says if the conspiracy against rights, yeah, we got one cooking. If the conspiracy against rights includes an attempted kidnapping, I almost went to jail by design. Or if it includes an actual kidnapping, someone landed me in prison on false charges, and they knew I was innocent. That's a conspiracy against rights that includes an attempted kidnapping or a kidnapping. That's a capital offense. You go back to 241, the third paragraph, and it says, if the conspiracy against rights includes a kidnapping or an attempted kidnapping, they could get the death penalty. Why wouldn't I want to know when that's happened? And I'm going to give you the idea, the notion that I plugged these into or spread these over that kept me awake a lot of times when I, in retrospect, thought about all the times the cops knew this person was innocent and they ended up in jail for 2 days, 6 weeks, 6 months, a year and a half, 10. I've met every breed. And looking back, I recalled a bunch of different people that were in deep kimchi when everybody knew they were innocent. Everybody knew. And so you have an instance where it's a conspiracy, because there's more than one person, to deprive somebody of a right, their liberty, by seizing them and confining them for ransom or otherwise. And 18 U.S.C. 241 makes that a capital offense. Thanks for waiting to come on the call, folks that joined us late just a moment ago. In the chat, there's a PDF document that contains 18 U.S.C. 241, 18 U.S.C. 1201 on one page, and that's our focus today. I'm going to post the recording of this episode in my podcasts, so you'll have it. Download the document now. So, did somebody who knew I was innocent prosecute me and put me in jail, or get an arrest warrant that arrested me or caused my arrest when they knew I was innocent? Or did they conspire to get an arrest warrant and not quite get one? Well, that's an attempted kidnapping. They knew I was innocent. They applied to this judge. They had an assistant, and the two of them went to this judge for a warrant, and they knew I was innocent. How is that not an attempted kidnapping? To unlawfully seize and confine you, haul you away, and hold you for ransom or otherwise? 18 U.S.C. 1201. And so when I reflected on everybody I'd met, the people I could recall, the crimes against them that I could remember, a whole bunch of them ring the dinner bell. Innumerable amounts of them ring the 10-year felony bell in 18 U.S.C. 241, for which you're going to have a state analog, a state law that reads very much the same way. And an analog, a state statute that reads very much the same way as does 18 U.S.C. 1201, kidnapping. And so you can bring your charges under that to fortify your allegations or someone else's allegations if you're in the vein where you might get into helping people, writing and filing criminal complaints, of course, to not have a refusal of federal jurisdiction dissuade you. Memorize the language of all four statutes, 2 fed and 2 state statutes like 18 U.S.C. 241 and 1201. And keep those with you all the time. You're going to find instances, because I didn't have to look very far. It's been enough to keep me busy for 30 years, finding innocent people. And I've already briefed the definition of innocence. There's a video of it on my YouTube channel, Definitions of Innocence. If the tax is not imposed by clear language, you're supposed to be able to walk on the charges. If the government can't put its finger on the law that imposes the tax before putting its finger on the citizen's property, then you don't owe it. Or you're innocent. You got all these standards of innocence, and they ignore them even when they know somebody's already got their explanation of the law on the record, and they said they believe it. They said it under oath with a notary. This is what I believe. Well, that's not good enough for us. We're public servants. You're innocent, and they're going to take you to prison. That's a kidnapping. And more than one person knows you're innocent. You and the judge, and the prosecutor, the prosecutor's assistants. I would presume that the U.S. attorney for the district even knows of it, not just the prosecutors. They are assistant U.S. attorneys. And I'd make the allegation against all of them, under state law and under federal law. And so either way, I'm going to arrest you. Servant breath. And I'm alleging in my written, sworn criminal complaint that it's a capital offense. So I can arrest you for the rest of your life, as can every American. Can you think of a stronger claim under the law than that, beside justifiable homicide? You don't have to go there. Everybody can arrest them until they're prosecuted. So that's where I was driving with this particular exercise, is to the conclusion that you can impose the right of citizen's arrest of a felon for life on a public servant that does what they do all too often, especially in tax trials. They can't even explain the law, they won't interpret the law, and you go to prison. So already a whole bunch of tax U.S. district judges that hear tax cases and prosecutors that know they can't prove the law imposes a tax. They'll tell you how the law operates in their opinion. It'll never include Section 83 or 1012. So they know you're innocent because they can't explain the law. That's one of the definitions of innocence. So in every tax trial where someone goes to prison, it's a kidnapping and conspiracy. It's a capital offense. And you only had to look at these two statutes. A judge wouldn't be prosecuted under state law. So federal jurisdiction all over that. A state tax court judge hearing criminal cases, aren't they using the mail to get you into court? That kind of makes it federal. Yeah, 18 U.S.C. 1341, frauds and swindles, mail fraud. Aren't they using the internet for some communications by email or Zoom calls? 18 U.S.C. 1343, fraud by wire, radio, or television. Felonies. So there's a lot of ways to get them right into federal law, which is written very broadly. I have to say, federal statutes are typically more broad than our state statutes. State legislatures just have more to say or something, but federal statutes leave you out in Siberia with a burden of proof that legislation is supposed to put on you. They want to tell you how to act, and they want to tell you how not to act, so it is express, but state statutes just say a bunch more when you see them. Anyway, so I wanted to build a posture, and that's citizen's arrest for life. There's nothing I can do about it. You're subject to citizen's arrest for the rest of your life because you conspired with another person to unlawfully seize and confine and hold for ransom or otherwise someone you knew to be innocent. You contrived a scheme, conspired with this other, and you executed upon this scheme to deprive somebody of their liberty unlawfully. That's a capital offense. Citizen's arrest for life. Criminal complaining about a capital offense. This came into vivid play in Richard Boggs' case out of South Carolina, a case with which I have nothing more to do. But the jury verdict came in, 7 counts of tax evasion, guilty, and his hired criminal defense attorneys made no use of his 9 lawsuits that he had filed. I wrote the first 2 for him as a lead plaintiff in South Carolina. I wrote another 2 for a man in North Dakota, and Richard Boggs joined that as a similarly situated plaintiff. And then he wrote 5 of his own, took 3 of those all the way to the U.S. Supreme Court. He had some administrative correspondence, and all of this argued Tax Code Section 83 and citizens of the U.S. are only named in regulation. My core 2 findings in my 1994 treatise that we know they won't talk about it. They won't talk about it. You can't have it. We won't interpret it. Next case, please. And you go to prison. and he had pounded on my findings to that extent so everybody knew he was innocent. He obviously doesn't believe he has a duty, and a prosecutor, Mr. Potterfield, went to the grand jury and lied and says he's willfully evading taxes. What the hell do I have to do to convince you I don't believe I have a duty? So he was obviously innocent. His lawyers went to sleep. And then after the guilty verdict came in, he and I agreed, you got to start filing things yourself and hint at ineffective counsel because they didn't make use of all of this evidence available. It never came out at trial. And so I wrote him up. He was keen on serving the perps with successive affidavits that they can default on in 15 days. I gotcha. And then you serve another one on them and say you got 15 days to respond and they don't respond. I got you again. Third one, you got 10 days to respond. And the fourth one, you don't respond to these. You've defaulted. You are doing exactly what I've stated that you're doing in those affidavits. And those affidavits accused the judge, the U.S. attorney for the District of South Carolina, and the assistant U.S. attorney that was bringing the charges, Mr. Potterfield. And I think there were a couple of inspectors from the IRS, special agents, that were named as defendants to an allegation that this is a capital offense. The judge still has discretion to get out of this, so I'm not naming her as a defendant, but she's a hostile witness. They need her to be as corrupt as they are for them to succeed in this capital crime going down in open court. Fully briefed and discussed and complained of in the first affidavit called Affidavit in Commerce. He had contracted with somebody who happened to have a bunch of victories in the 90s in bankruptcy court using successive affidavits, unrebutted affidavits, to solve an alleged tax deficiency in bankruptcy court. And he won a bunch of cases. The government walked away from a bunch of cases. And Richard Boggs had contracted with him to follow this affidavit process. And I was supposed to write it. The documents were crap. And so I briefed the issues and made them very nice documents. And the finished product looked real good, but it had a hint of commercial law in it. And that was from Richard Boggs' insistence that things be done to a degree, just a hint, the way this guy wanted it done. And he paid the guy a bunch of money. So it's called an affidavit in commerce, and it has the word truth and honor and dishonor in capital letters here and there. But in his affidavits, he never cited any Uniform Commercial Code provisions, any maritime law, any federal commerce statute, didn't cite any authorities, no case law. So it was just a bullhorn. And so I had to write in my style, all the law, and then throw a dash of his crap on it. So when you get those on the flash drive, that's why it says affidavit in commerce. It is not the way I would have done it. But anyway, 4 affidavits, defaulted on each one. And so he put those as attached exhibits behind his first offer of proof. And he filed those and their exhibits as exhibits to the offer of proof, stating that they don't deny a word of this. It's a capital crime. Everyone knows I'm innocent. And now the court's on notice of all this. And then a second affidavit, or a second offer of proof, mandatory judicial notice and offer of proof with exhibits. And these were his 9 sworn civil lawsuits. The complaint from 9 different civil actions were attached as exhibits. And then his third offer of proof which pled 5K2 rules. 5K2 rules are rules that say when it comes to sentencing, the judge is in charge, but the judge can enhance the sentence if any of this criteria exists, 1, 2, 3, 4, 5, 6. And if any of this following criteria exists, the judge can reduce the sentence, 7, 8, 9, 10, 11, 12. And one of the 5K2 rules for downward departure, lessening of the sentence, mitigation of the severity, was victim's conduct. The government claims to be a victim. I didn't pay them that money, and so they're claiming to be the victim here, but look at their conduct. And it referred back to the offers of proof. Here are my 9 lawsuits. Here's all the case law I hit them with when I gave them that administrative notice. Here's the letter I sent to Potterfield a year ago in February asking to appear before the grand jury. And he said I could appear before the grand jury, no problem, come on in. I went in on the date that he told me to, and he said, go home, you're not testifying. And he turned right around and went back in that grand jury and said that I'm willful. When if you look at the second half of that letter that was supposed to go to the grand jury, the first half was to Potterfield, the second half was to the grand jury. You look at that and you know why he finally read the letter and said, no, you're not testifying. And you get the letter in the flash drive, on the flash drive, in the Boggs folder. And I'll tell you more about the flash drive in just a minute. So the grand jury was lied to. He was anything but willful. He's the best non-willful case to come along ever. Ever. Vernice Kuglin, John Cheek, Lloyd Long had nothing compared to what Richard had done. Nothing. And he stuck on very specific findings. Offense, you deprived me of Section 83, and you named me only in regulation. What were you thinking? Knowing from previous docket numbers everywhere, they can't talk about it. My key provisions, they won't talk about it. So, knowing that in advance, that's what he hit him with in those offers of proof. And then victim's conduct, they keep the law secret. They're supposed to tell me all about it. The courts won't tell me about it either, and they're supposed to. You're in violation of statutes. That's a conspiracy against my rights, and you're trying to kidnap me. You know I'm innocent. So right back in all of their faces with these offers of proof and their exhibits, just crushing them. So it's on the record, criminal complaint for capital offense against the judge, U.S. Attorney, Assistant U.S. Attorney, and 2 special agents from the IRS. How's that? And in this victim's conduct thing, he complains directly about it, saying victim's conduct, it's the basis for this entire thing. Keeping the law secret while I hammer on my right to redress, and I can't even get the law out of you? You'd rather have me in prison than if you'd have told me how I owe the tax, I'd have paid it and gotten on with life. But you won't tell me. So, just ballistically, politely enough, but he's a pro se litigant, and so there's a little bit of flair in the writings. But you get all these in the Boggs folder on the flash drive. That's for sale at my YouTube channel, Take From Caesar, my most recent upload at this point in time. It mentions flash drive right in the marquee. Get that flash drive. The Boggs file is right there. So he's got these 4 affidavits and their exhibits. You might not get the exhibits. They're specific to his case, but you'll get the 4 affidavits, then the offer of proof, number 1 and number 2 and number 3 and number 4. Number 3 argues the 5K2 rules. Number 4 argued entrapment by estoppel. What's his face? U.S. versus Talmadge, 9th Circuit, 1987. Talmadge was a felon under state law. And under state law, there was some kind of a shift in the interpretation of a particular statute that made him a felon, and they reduced the charge to misdemeanor. Pardon me. So he's reduced to a misdemeanor, and the sentencing judge says, well, don't buy a concealable weapon. And his criminal defense attorney said, yeah, it looks like you can buy a gun now. And he went to a federal firearms licensee, a gun dealer. And the dealer said, yeah, looks like, yeah, you can buy a rifle. So he bought a rifle and got busted for it, and made the argument that he was entrapped. One judge's comment, verbal comment in court, one verbal comment from his attorney, and one verbal comment from the firearms licensee. The attorney might have put it in writing, but that's all he had. And it was enough to overturn his conviction. The Ninth Circuit said the conviction violates due process. He's been entrapped by estoppel. That was the doctrine that he was found innocent under, that he in good faith believed experts. They called the federal firearms licensee an expert. He's not a federal public servant. He's a private individual that runs the office in the shop, but the regulations put a burden on him to know everything. That was enough for the court to recognize the dealer as an expert, a federal expert. So, with that in mind, and upon viewing my memorandums, my briefing, everything is from judges. I follow case law all the time throughout my pleadings. And so it wasn't, it was an expert that told me in regulation that my cost is the value of any money or property paid. 26 CFR 1.83-3G. It was an expert, Congress, that wrote Section 83 that says only the excess over the amount paid is gross income. That wasn't some dream of mine. It was an expert in Publication 17 that said your services are your cost. And so I relied on nothing but experts, lawmakers, judges, and bureaucrats in their statutes, regulations, and memorandum decisions. And that's a good reason why the court should find grounds for dismissal of the 7 convictions, 7 counts of tax evasion. So he made these submissions, offers of proof, 4 of them, after 4 affidavits, and they all had exhibits attached. And then you have a motion to dismiss for entrapment by estoppel, a motion to dismiss based on the briefed issues about the tax code. There was another briefed issue. Oh, he submitted his own challenge to territorial jurisdiction. It's the non-resident alien argument, whatever you want to call it. I tried to talk him out of it, but I went through it and corrected a couple of mistakes he had made, and he filed that. It can only make his appeal way harder. As the person who, at that point in time, was the one slated to write his appeal, I objected, saying, you're giving him a tool to screw you over with, and it's going to make your appeal way harder. You're giving him an out. And he just had to do it. You'll get that also on the flash drive. And one other motion, probably the 5K2 motion instead of the offer of proof. And all of it is briefed by me. It's my latest briefing, a very clean briefing of tax law for a guy that's the dream petitioner for a lack of willfulness defense. Nobody's done as much work as this guy did, trying to convince the government that he's innocent. And they ignored him. They lied to a grand jury. His attorneys went to sleep. The jury rendered a guilty verdict for 7 counts. And then it was his turn to start filing documents. That's when I went to work. The private attorneys 4 weeks later were fired, and then it was just me and the DOJ. And then Richard Boggs thought he should mess with what I had written, which took away a strategy that I had embedded in the process that I was going to file. So it rendered a bunch of stuff I had thought about for a year moot, irrelevant, and he protested us too much. He got really rude about me trying to tell him what to do, so I quit the case. What I do is what I do. I've done it 30 years now, and he's watched me do it. It's my 1994 treatise that's been in my head 35 years. 32 years. And I'm not the one to make suggestions on, you shouldn't do that, you're screwing up. And he just threw it right back in my face. So you're going to screw up without me. If you care that little about your own liberty, far be it for me to spend another calorie protecting your liberty. Farewell. So up to that point, you get all of this in the Richard Boggs folder. And the other statute prominently pled in there is 5 U.S.C. 706 that says the court shall interpret statute and decide all constitutional issues in front of it and rule whether or not it's arbitrary and capricious, beyond statutory authority, if it violates the Constitution. They are required by law to do that. And they're not doing it. That's an attempted kidnapping. You're conspiring against my rights under that statute. 241, a federal felony. How bad? Well, they know I'm innocent, and so it's a capital offense. They could get the death penalty for it. All of that is robustly pled or pleaded in the documents from the Richard Boggs case that I wrote. And you get those in the, you open the folder, it says IRS. There's one of those called APA, that stands for Administrative Procedures Act. Open that one. And then there's several folders, and you'll have one that says Boggs. And those are the pleadings that I wrote for a criminal case with one objective. After the guilty verdict, but before the sentencing, the judge can set aside the conviction if the evidence weighs heavily against the verdict. That was the target. And the documents that I wrote to obtain that are what you get in the Boggs folder in Microsoft Word. You're welcome. A couple people on the call have their flash drives. Christopher J., Diane Lynn. I have something that's pulling me away, and John from PA as well. I've got a stacked afternoon, so I just can't take any calls right now about the flash drives. But believe it, and watch your inbox for another TalkShoe notification, because I will be able to take calls on the next one. With all that having been said, this has been No Confidence for June 3rd, 2023. My name is David Myrland. None of this is legal advice. I'll see you next time.